Good morning, students. I hope you all are doing well. Please take care of yourself. And we have been, as you all are aware, that we have been instructed to conduct the classes online. I'll be conducting the classes online like any other faculty. And in today's class, you are going to have a recorded presentation, and we are going to look at legal capacity. We have already looked at contracts from three perspectives: the promise, the agreement, and the contract itself. And legal capacity is related to the promisor and the promisee, and basically whether by law somebody has a capacity to enter into contract, and that is what we are going to study today. So capacity to enter means a legal competence of a person to enter into a valid contract. That means that person should be able to enter into a contract, and that contract becomes enforceable. And in general, there are people who are not eligible to participate or enter into contract, such as minors or individuals at a certain age as defined by each legal system or statute of that country. This basically means that the age of a person is determined by different legal systems in terms of whether somebody can enter into contract or not. And one of the reasons why this is provided is the legal capacity under that context. When somebody says the person cannot enter into a legal contract or cannot participate to become a party to the contract, is a protection against this kind of people. For example, a minor or a person who is defined by a legal system within that statute of that country. Legal capacity can be broadly understood in three contexts. One is one party is too young to contract, that is a party who is a minor. Another is a party who is permanently insane or unsound, and we're also going to look at another one which is a temporarily unsound mind. Now let us look at the protection for the minor, a person who has not attained the age of maturity or age of majority. Basically, this means that law protects a minor from getting into a contractual obligation. Minors are exempted from being part of the contract, and that is why it is known as age of majority or minor. The general principle is that if there are any contracts which is in the benefit of a minor, the contract becomes voidable, and if it becomes detriment to the minor, it becomes void. Exceptions are that there are contracts, particularly in the common law system, where they have accepted that contracts made by the minors will be understood as an enforceable contract. These contracts are known as necessaries, the contracts of necessaries, which is important for a minor. For example, you as a student, you can be held or you can be held responsible if you borrow a money for your own use, such as for your food, for your shelter, or for your stationaries. So this is known as contract of necessaries. If you look at a case of Nash versus Inman, the plaintiff supplied clothing to the defendant, a Cambridge undergraduate, to value of 1,145 pounds and 10 cents, and clothing included 11 fancy waistcoats. The defendant argued that he was minor at the time that goods were supplied and they were not necessaries. The defendant's father gave evidence that his son was already amply supplied with coats. The court held that onus of proving that goods supplied were suitable to the condition in the life of a minor and the defendant was not already adequately supplied with such goods. The plaintiff had failed to establish this, and therefore the plaintiff could not recover his money or the price from that minor. And if you look at that, the codes are there to determine what is necessary for a necessary contracts and what is not a necessary contract for a minor. Now, a minor is bound by an employment of contract on the whole if it is for benefit. And this is particularly true in case of British contracts or the common law system or English contract system. There is a case known as Doyle versus White City Stadium. The plaintiff, a minor, applied to British Boxing Board of Control for license as boxer and agreed to be bound by rules of the board. He issued a boxer's license. Few months later, the rules were altered, which means the rules were changed, and instead of rule providing that boxer's money was to be stopped only if he was disqualified for deliberate fall, the new rule was in that case of disqualification, boxer was to receive only certain expenses. The minor or that plaintiff had arranged box to return for £3,000, win, lose or draw, but he was disqualified for falling. Both did not give him his £3,000, and as a result, the minor sued the defendant and plaintiff claimed the whole amount. The court held that contract as a whole between plaintiff and both was beneficial to the plaintiff, which means plaintiff was a minor and it was beneficial to the plaintiff, and therefore it is binding on him. However, if each contract is interpreted as an employee contract or a contract for necessaries, it will be regarded as voidable. That means since he is still getting some amount, the minor has a right to reject or to accept that contract, and that is how if you look at from the perspective of benefit of the minor. Now, if you look at from your reading material about the age of maturity or age of majority, if you look at in terms of United Kingdom, it says that in English law, contract for necessaries, goods suitable to condition in the life of a minor. If you look at the West Coast case, that whether the West Coast court was, important for that minor or not, is actual requirement at the time of sale and delivery. So there must be a reasonable price, and if this reasonable price person is sold at a reasonable price, that the good is sold at a reasonable price, and contracts are necessary for the minor, it is considered to be valid. And also, if there are employments, apprenticeships, trainings, for example, you go to a court, do for a paid internship, then it is in your benefit if you are a minor, which means that these kind of contracts are valid under the English contract law. Similarly, if you look at Dutch, so this is a civil law system, and this is, if you look at Canada, if you look at many other legal systems, contracts must be contested by parents. That means in some cases, parents must be there. The contract's valid if contractual relationships are normal for minors to enter into. Contract does not put the minor at an economic disadvantage. That means if the minor is going to have an economic disadvantage, that contract is not considered as a valid contract. Now, if you look at Germany, the age of maturity is 0 to 7 years. But 0 to 7 years, the contract is definitely invalid. But if you look at 7 to 18, only legal benefit and no obligation. So if there is a contract, for example, if a contract of necessary, which means that if somebody buys in case of common law English contracts, that minor is liable to pay the reasonable price for the goods that he purchased. But if you look at the German contract, it is not that. That means that there can be no obligation against the minor, and if only legal benefit is there, then yes, for example, paid internship. So if he has no other obligations, then that contract is considered to be valid. And if parents or guardians give money for a specific purpose, then that kind of contracts are valid. If parents and guardians give pocket money, that is a valid contract. That means that it is in the benefit of the child or the minor and not against the minor, so no obligation against them. If parents or guardians retroactively ratify before giving them, if parents or guardians say that, okay, I am going to give you this money or this kind of gift with no obligations, then this kind of contracts will be valid. Otherwise, if contracts are voidable at the option of the minor, then it may be valid, but otherwise it is not valid. That means that only contracts that, whether if it's in the benefit of the minor, or if that contract is such that the minor has an option when he attains 18 years of age to decide to be able, to be able to enter into a contract, or he says no, I don't want to enter into contract, then it will not be, you know valid contract. So that is at the voidable at the option of the minor. Now, if we look at the judge, so minors need not need parental, guardian, or consent for all the contractual transactions. That means minors can never enter into contract in case of Dutch contract, but such consent is presumed to be given normal transactions for children of that age. So between the children of that age, it is considered to be valid. Now, if you look at Bhutan on the age of maturity, the Section 20 of our Contract Act says a person shall be competent to enter into contract if he or she is age of majority according to law applicable to him. That means that Contract Act really doesn't say at what age a person in Bhutan cannot enter into contract, and it depends on another act which says that the age of majority of a person is considered to be, eligible for contract. Now, if you look at that after Section 20, as we have seen that under the age of contracts, it really doesn't say which age is considered as minor and which is considered as age of maturity. But if you look at Marriage Act of Bhutan, I think there's a slight mistake in that too. Not 2017, but it is 1980. So under the 1980 Marriage Act, age of marriage shall be 18 years of age for both the bride and bridegroom, which means that any marital contracts related to marriage inheritance would be correct to say that if they have attained 18 years of age, it will be a valid contract. But this Marriage Act does not necessarily extend to other areas of contract. So which means this Marriage Act is a specific act which generally pertains to inheritance, generally pertains to family laws. So only within that it would be correct to say that age of majority is 18 years of age. Now, if you look at Child and Protection Act of Bhutan 2011, Section 72 says a child in conflict with law is a child who is above 12 years of age and found to have committed an offense, which basically means a child who is below 12 years of age is not eligible to enter into any form of contract. But if there is a child who is 12 years old and who has committed an offense, means if there is a legal liability under Child Protection uh, Care Act, so which means that that person will be liable under that, but very restrictive ones. But if you look at Labor and Employment Act of Bhutan, the age for admission to employment is 13 to 17 years shall be limited only to categories of work. Now, if that category of work is considered, it would be an employment contract, which means employment of contract between a child in Bhutan who is 13 to 17 years of age will be valid as long as it is permitted by rules under the Labor and Employment Act of Bhutan. Now, before we start with this case, if we look at the civil service employment, to enter into civil service is minimum of 18 years of age. That means civil service contracts are valid only if both the parties are 18 years of age. Since civil service is a legal person, whereas employee is a natural person, that employee must have attained minimum of 18 years of age. Now let us look at case known as Kiefer versus Freight House Motors Inc. In this case, the plaintiff Stephen Kiefer entered into contract with the Freight House Motor to buy a 1960 Willys station wagon. The cafer paid the contract price and took the possession of the car. And during that time, cafer was 20 years old. He was married and he was father of one child. Cafer had difficulty with car which he claimed was caused by cracked blocked, and he wanted to return it back and get the money, but he couldn't get the money, and as a result he sued the plaintiff, the White House Motors Inc. The court held that law governing agreements made during the infancy reaches back many centuries. The general rule is that contract of a minor, other than for necessaries, is void or voidable at his option. The only other exceptions to the rule permitting disaffirmance or as a statutory involve contracts which deals with duties imposed by law such as contract of marriage or an agreement to support an illegitimate child, which means that in this case he was married. But under the US law you have to be 21 years old, not 20 years old. So under the marriage law it is 20 years old. Just because you are eligible to marry does not mean that you are also obligated under the contracts. That is basically what this judgment is trying to say. Which means that if he has a child, if that child is illegitimate, he has an obligation to the child, but not necessarily to the contracts outside of the Marriage Act. Which means this contract has nothing to do with his marriage. And court further went on to say that general rule is not affected by minor status as emancipated is as or unemancipated, which basically means that appellant does not advance any argument that would put case is one of the exceptions, but rather urges the court that matter of public policy adopt a rule that an emancipated minor over 18 years old be legally responsible for his contract. The underpinning of general law allowing the minor to disarm his contracts were undoubtedly protection of minor. So it was thought that minor was immature, both in mind and experience in that. And that is the reason why a minor is protected against contractual obligations because the minors are not mature enough, they are not experienced enough to understand the consequences of entering into a contract. And therefore, the court says that he should be protected from his own judgments as well as from adults who take advantage of him. They know that he is just 18 years old. By law, he is not eligible to enter into contract. Therefore, law must not only protect he because he is immature, he is inexperienced, but also from other parties taking advantage of his immaturity. The court further went on to say that doctrine of viability of minors' contract often seems commendable and it's just, it is correct. If the beans that young knave Jack purchased from the crafty old man in a fairy tale Jack and Bean had been worthless rather than magical, it would have been only fair to allow Jack to disarm the bargain and reclaim his cow. That is another case. So they cited another case that it would have been correct, but it is not because the minor is protected by law. However, in today's modern and sophisticated society, infancy doctrine seems to lose some of its claws. Therefore, the court said that for this court to adopt rules that appellant suggested and remove the contractual disabilities from minor simply because he becomes emancipated, he becomes eligible to be married, would be to suggest that married minor is somehow vested with more wisdom and maturity than single counterpart, in which the court basically means that if somebody is married, if you say that because he is married, he is mature and should be considered as a mature person, be able to take the decision and then obligated to perform the contracts, it would be wrong. The court says that, however, logic would not seem to dictate his result, especially when today a youthful marriage is often sometimes indicative of lack of wisdom and maturity. It says that just because you marry at early age does not mean you have the maturity. Basically, it indicates lack of maturity and wisdom. You don't understand the underage marriages, and that is why you enter into marital affairs. And therefore, the contract should not be bound to the person unless he is legally fit, which means that under the US law it's 21 years old, and in Bhutan, if you look at it's 18 years, 17 years, so it depends on different statutes. Let us look at another case. There is a case known as Proform Sports Management Limited versus Proactive Sports Management. So these are both the legal persons. At the age of 15, when he was a minor, the footballer Wayne Rooney had entered into player representation agreement with Clement, whereby the Clement company was to act as his executive agent and represent him. Under the Football Association rules, Rooney could not become a professional footballer until he reached age of 18, and therefore he was employed as a trainer. So instead of employee, he became a trainee. The claimant alleged that the defendant had also entered into player representation agreement with Rooney. His contract was still operating. The claimant therefore brought an action against the defendant for unlawful interference with or procuring the breach of his contract with Rooney. The court held that agreement with claimant was not enforceable against Rooney because she was a minor, and the general rule was that contract was viable at the option of Rooney. It was not analogous to contract for necessaries and could not be analogous to contract of apprenticeship education. So here, if you look at apprenticeship, he was considered as a trainee, which is beneficial to him. That can be done, but you cannot impose other obligations. Since Rooney was already with the football club and could not yet become a professional footballer, therefore, contract with agent did not enable him to earn a living or advance his skills because he was employed as a trainee and not as an employee, and therefore the court followed that defendant could not be liable for torts of inducing breach of contract since his contract was viable at Rooney's option. So it was the Rooney at the Rooney's option whether to enter into that contract or not. Otherwise, the contract will become invalid or contract will not be enforceable. Now, this is a second category under the legal capacity. First, you have looked at as a age. One is a age where the law protects against imposing a legal obligation. Now, the second is the mentally unsound or insanity, or is also known as insanity. And we are looking at the second category. This does not matter whether you are old or young. This applies across all categories, all ages, but depends on the conditions, the mental condition of the person when he entered into contract. Mentally unsound, which means that a person actually, in essence, a person should be able to participate and embrace the effect of one's action or ability to understand one's decision and consequences related to his or her decision. So that person must be actually sound enough to understand and anticipate his decisions, what would happen if he take that decision. It may also be held as ability to take rational decision, sound judgment. That is known as mentally sound. Mentally unsound means opposite to that. Mentally unsound means someone who doesn't have mental capacity, then that contract would either become void or have a guardian void with exception for necessaries. So if you look at minors, it's also because although the age is put there, one of the reasons is his immaturity. He cannot take the decision. In that case, the contract becomes voidable or void. If it is contract for necessaries under the English law, then it is valid, but otherwise it is not valid. Most states define standard of mental capacity as to whether or not two parties understand effect of meaning of the words in cognitive sense. So which means that generally people, in many jurisdictions apply a cognitive test to see whether that person is mentally able to take a decision and enter into a contract. And this is also known as a reasonableness, that a reasonable person can in fact do that or not, and that is compared with that person whoever says that I was mentally unsound when I entered into contract. This mental unsound can also be a permanent mental insanity, or it can also be a temporary insanity. Now, if you look at the civil law systems, courts can order formally declare a person incapable of entering into valid legal transaction. Courts will then appoint guardian to conduct all binding transactions on behalf of that person. Courts can invalidate certain transactions. So, which means that courts can actually formally declare that, saying that, oh, no, that person. So, which means the court must conduct a test. We have looked at that cognitive test as one of the tests to determine whether that person has entered into contract correctly or not. If you look at German courts, it says that custodian appointed who acts like a parent in situation of minor responsible for granting consent. So now in case of minor, if there is a custodian, there is a guardian who takes the responsibility of taking the decision on behalf of that minor. Then if he gives the consent, then it is considered as it's a valid contract. Then it's considered as valid contract. Now if you look at Bhutan, mentally unsound, the definition of mentally unsound, the answer is unclear. There is a court procedure to declare someone of unsound mind. If you look at Election Act, for example, a person shall be disqualified for registration in electoral roll of constituency if such person is of unsound mind and then stand so declared by competent court. So that means the onus has been provided, given to the court. The discretion is lies with the court to determine whether a person is unsound or sound. He was insane or insane and not seen during the period when he entered into contract. Now, if you look at now in relation to mentally intoxication or mentally unsound in relation to alcohol and drugs, generally in the business setting, it is considered that those who are intoxicated by alcohol drugs aren't considered to be lack of capacity to enter into contract. Courts usually decide that people who are voluntarily intoxicated can't be allowed to avoid the contract obligation. Which means, for example, if you look at discotheques, if you look at karaoke, if you look at entertainment centers, a lot of people are already intoxicated voluntarily, but they still go and buy drinks, buy all other things during the party time. And this kind of contracts are generally considered to be, correct. And it says that it is best to not to sell services or products to anyone who might be under the influence in business setting generally. But contract can be viable if parties have said that yeah, I was half drunk, but I don't mind that I have entered into this contract. I'm ready to do that. So it is considered to be correct. And majority of courts want to look at to see if intoxicated person knew what they were doing rather than sober that they knew. So it is the burden of the proof, or if you look at the other, if other party finds that he's not totally intoxicated, it is correct to say that to that person, then it is considered to be correct. So which means that if Mr. A is drunk and Mr. B didn't know that he is drunk, and then if they enters into a contract of sale, then that contract of sale will be valid. It will be contractually enforceable. Only if that Mr. B knew that Mr. A is totally drunk, and then entering into contract is going to be not correct because that Mr. A will not be able to take rational decision. Then only that contract can be considered as not valid. Temporary means that drinking of alcohol is one example. Now, if you look at the civil law system, Germany and Netherlands, this is that if a person can prove or he was suffering from temporal mental disturbance, unconsciousness, contract is set aside. Reliance of other parties immaterial. Now, for example, today we have a COVID-19 case. You are in law school, then let's say you have a business and you enter into contract. You are so much disturbed by the COVID-19, the fear of COVID-19, and you are unable to take a rational decision. And out of all those conditions, you just sign a contract, and then later on you realize that you made a mistake. You can actually go to the court and say that I was temporarily mental disturbance. I was unconscious during that time. Okay, which means that then you can actually go in terms of German and if in terms of Germany and other Dutch reliance of other parties. So that means it doesn't matter whether other party has relied on you or not, as long as if you can prove that you were suffering from temporary mental disturbance, then you will not be accountable under the contract act. Now if you look at British, it says that unless the counterpart knew that other party was unable to rationally understand the nature of contractual agreement he or she was about to engage, the contract is binding. That means that the other party, your party, Okay, Mr. A and B enter into contract, and then if Mr. A is mentally unstable, then unless the counterpart knew that other person was unable to rationally understand, party B is able to understand that A is not rationally is unable to rationally understand nature of contract agreement, he was able to engage, the contract becomes still binding. Okay, for example, selling a farm, if you look at the case that you will remember that in our reading material. Now, mental unsound. Now, if you look at section 20 in Bhutan, if you look at mental unsound, section 20 of the competent parties, if you look at that, so in the section 20 it says parties shall be competent to enter into contract if he or she is of sound mind. So that means the law only says it's sound mind. Now section 21 says a person is said to be of sound mind for purpose of making contract. At the time of entering into contract, he or she is able to understand the contract and form a rational judgment of effect of the contract on his or her interest. So that means that it's more closer to, in fact, common law system. At the time of entering the contract, he or she is able to understand contract, form a rational judgment in effect of. So one, he understands the contract. He understands what is written in the contract or what kind of end contract he's entering into. Second, he knows and he takes a rational decision, and then he also knows what would happen to that decision, the effect of that decision, entering what is the effect of getting into that contract, what kind of obligations he will be obligated if he enters into contract. For example, selling a car. Okay, once he gets the money, so the rights of the car ownership goes to the other person. If he knows that this is going to be the effect, then it is considered as mentally sound. Section 22 says, person who is usually of unsound mind but occasionally of sound mind shall be capable of entering into a contract when he or she is found she is of sound mind. Then let's say, for example, somebody is always having a problem, a medical problem, where he enters, or sometimes he becomes sane, sometimes he becomes sound mind. He is able to take a decision, he understands the things, but most of the time he is not able to do that. But if he enters into a contract during that period of time when he is able to take a decision, then that contract will be valid. A person who is usually of sound mind but occasionally of unsound mind, whether because of illness, drugs, intoxication, or any other cause, shall not be capable of entering into contract when he or she is of unsound mind. Now, if you look at the previous slides, we actually looked at generally intoxication is not considered, but here in Bhutan, one illness because of the diseases, one use of drugs, one because of intoxication, can be alcohol or any other intoxications. So if he enters into contract during that period of time, generally let's say he's a rational person. Mr. A is always okay, rational. He has no other problems, but suddenly he drinks a glass of wine or a glass of beer, and he becomes intoxicated under that alcohol, and then he enters into contract. That contract is considered to be not to be correct. Okay, that contract is not valid contract. Now, burden of proving that person was of unsound mind at the time when he was entered into Shelby party, alleging she was unsound. So basically, generally, the burden of proof lies towards the person who is claiming that. So generally, it is the promisee, or it can also be a promisor. Okay, generally it can be a promisor. So promisor says that, okay, I'm ready to give you this, and then Mr. A gives that, and then tomorrow he realizes that he made a wrong decision, and then he goes to court, and then it is his duty that during that period of time he was insane, he was not of sound mind but of unsound mind at that time, and then he can invoke section 22 to get out of that. Now if you let's look at a case of Kandik versus Broadband. Okay, Kandik was 59 years old, sheep rancher, and who had on occasion sold his lamb crop to the Broadband. Okay, and then they drafted a contract. Okay, they drafted a contract. They were able to, and then they amended this contract in 1963. Okay, and then he decided that he will sell 2,000 acres of range land went for 40,000, but later on it was found that the value is around 89,000. And he also looked at the interest in company with the broadband was a director. So he did all that, but later on he wanted to resign that contract. And interestingly, this contract, his wife was actually the Mr. Kundik's wife was a witness, and she realized that they made a mistake, and then she in fact filed a case, and she is known as ad litem for purpose, ad litem witness, which means she was a de facto witness in that. And then she filed a suit in the court and said that no, we didn't want to enter into contract. And she then cited that her husband was suffering from a kind of a psychiatric problem, and he has psychiatric treatment in 1961. And then the case went to the court, and court looked at all the evidences, okay, and found out that the court found out that yes, he had a history of psychiatric treatment in 1961, but not before this one, and there were no doctor, evidences to show that he was actually, having a psychiatric problem when he entered into contract during that period in 1963, which was after 1961. He had a mental problem, and the court said that he was not mentally competent to compete. So the court said that it is not that he was mentally weak; he was completely correct during that time. He is, in fact, his wife was there as a witness. They have amended the contract. They have drafted the contract. So everything was done, and therefore, the court said that the defense of insanity is not correct in this case, and therefore, the case they could not get, resign the contract, but they had to enter into contract because the defense of insanity, they lost the contract. Now now in this country process brought when the court came up with a number of principles, and court said that mental capacity to contract depends upon whether the allegedly disabled person possesses sufficient reason to enable him to understand the nature of effect of the issue. Even average intelligence is not essential to valid. So basically, we have to have a very rational mind. Mental capacity to contract depends on whether allegedly disabled person possesses sufficient. If he knew sufficiently that what kind of contract he is entering into and the effect of that contract, then it would be considered as valid. The court said that if a maker of a contract has sufficient mental capacity to retain his memory without prompting the extent and condition of his property, and to comprehend how he is disposing of it, to whom and upon what consideration, then he possesses sufficient mental capacity to execute such instrument. Basically, that means that if he is able to know what kind of contracts he's entering into, what kind of the results of that contract would be, and if he's able to kind of anticipate everything, and then if he executes the instrument, if he enters into the contract, that contract would be considered as valid. The court also said that in the present case in country versus broadband, there is no evidence of overacting or fraud on part of defendant, and while there is some evidence of change in conduct, plaintiff business affairs the record lacked any evidence that his family and friends noticed a deficient mental condition. That in the current case, the conduct was correctly, he was, correctly in that case, and he was not acting insane. He did not have any of the insanities that they, his wife has in fact asserted in the court. And therefore, he, he lost the case in case of insanity. So he lost the defense of insanity. So this is the end of today's lesson, and in today's class, just to summarize, we have looked at legal capacity, we have looked at legal capacity, and we have looked at the purpose of legal capacity. The purpose of legal capacity, in short, is to protect a person who is unable to comprehend the contract and take action or take a rational decision and anticipate the effect of that decision. And we have studied two categories of legal capacity, the minors and mentally unsound. And in the minors, basically minors is, we have learned that Minus is the age of majority. In some jurisdictions, known as age of majority. And it is also known as exceptions under or exemptions or exceptions under the minor in terms of various jurisdictions. In fact, we have also looked at definitions of minors differ in different jurisdictions. Definition of mental unsound also differs in different jurisdictions. And we have also looked at in some jurisdictions where minors are not exempted from contractual obligations. So it's such as British systems or American systems where contract of necessaries are recognized. This means that the minors are accountable for their actions, the decisions that they take. But that is limited only to contract necessaries, which depends on the court how to define what is necessaries of contracts. And we have also looked at another category known as legal capacity, insanity, or unsound mind, or mentally unsound. We learn that validity of contract when a person is temporarily sound, though when he or she is most of the time insane or mentally unsound. And we have also looked at a situation where generally a person who is always mentally sound can become mentally unsound, such as under the drugs, under the alcohol, under the illness. A short period of time, the person becomes unsound, mentally unsound, and if he or she is enters into contract, that contract is either becomes void or no, voidable at the depending on the different situations. We have also looked at two important cases where the definition of sound and the purpose of mentally unsound, the purpose of minor is defined. And with that, we come to the end of today's session. And thank you for your attention. If you have any questions or anything that you clarifications that you need, send it to your class captain. And the class captain will forward all the questions to me. I will either respond in next class or send you in writing to all the students. In the next class, we are going to study creating this, that is setting a contract aside in terms of understanding what is concerned. And I will send you the instructions tomorrow. The reading materials and please read the reading materials and come to the class and stay safe and stay healthy. And with this, we are coming to the end of today's class. And the next class we will be studying on mitigating factors. If you have any doubts on this, let me know. And meanwhile, I will send you a few of the articles. And for today's uh, the remaining time, I want all of you to uh, take your take out your laptop and then you send me a two paragraph summary of what you have learned in today's class. At the end of this class, we will still have 15 minutes to go. So within 15 minutes, you write down whatever you've understood from this class and then send it to me by a Google Doc directly. Okay, you don't need to send it in that the format that I send you. Just send me the email or by Google Doc. Okay, send me two paragraphs and I will look at that and I will get back to you about this session if there are any important things